Hello, ladies and gentlemen. This is Alex Steepin for the Trademarkia podcast interview with Antoine H.M. Wade, trademark attorney. Hello, Antoine.
Hey Alex, how are you?
All good here in Warsaw, Poland. A lot of our clients and viewers are really interested about trademarking personal brands in sports. And as I understand, you're an expert in that field. Is that correct?
Yes, that's correct.
Could you tell us about your professional journey? How did you get to this point? How did you find out that this was something you're interested in and something that gives you satisfaction?
Yeah, so my journey started back in 2017, maybe a little bit before then, 2016, when I was in law school. Um, I was a full-time law student and also a part-time entrepreneur. I started a clothing brand um, during my last year of law school, and that's when I discovered the importance of branding and trademarks. And I had a close law school friend that suggested that I trademark my logo. And I always heard the word trademarking, but never knew the legal nuances and just, how to even navigate the process. And so she told me that she would assist me with trademarking my logo. And we went through the process, and it was something that was an eye opener. And coincidentally, my school, after having a crash course of what the trademark process was about for my own clothing brand, my school was actually offering a trademark clinic that afforded me the opportunity to work with pro bono clients that were also interested in trademarking their brand. And I felt it was a very a crazy set of events how that happened. And so I just went out on a limb and registered for the class. And my first, I would say, within the first month of the class, I was able to respond to an office action, which is also known as a refusal letter. I was able to respond to an office action from the USPTO that afforded the client that I was representing at that time trademark rights. And it was, I felt very accomplished. And just from that experience, it, it, it gave me the drive to seek a career in trademarks. So I actually have been studying and practicing trademarks maybe 2 years before I even received my official law license. And the rest is history from there.
Amazing. And how long have you been with Trademarkia?
I've been with Trademarkia since April of 2023. So we're actually coming up very quickly, almost at the 2 year mark. And prior to joining Trademarkia, so, as I mentioned a few moments ago, I've had the experience with trademarks dating back to 2017. So I would say 6 years prior to joining Trademarkia, I've been very deep into the trademark world.
What could you say about the importance of registering a personal brand for sports professionals?
So for sports professionals, I would say that the importance will be because you have, depending on uh, the audience that follows you, like the magnitude of your following. Most sports professionals, they have a very large following on social media. They have, in today's world, most athletes are venturing into media as well. So you will see that a lot of these athletes, they have podcasts, and then along with those podcasts, they may be selling merchandise as well. And so, it's very important because you just never know who's following you, what what people out there across the world, not just in the United States, because people from outside of the United States can also apply for trademark rights as well. And, there have been situations, um, where athletes, or just not even just athletes, people in business, they fail to protect their brand or file trademarks for their brands. And, um, they would essentially lose their trademark rights to someone that even knows that you're using a particular trademark in connection with your business, or just unknowingly. And so you never want to just take that risk of not filing the trademark application as soon as possible. I would suggest that you go through the trademark process once you have established a business idea, a clear business idea, and what services and products you want to offer. I would suggest that you go through the trademark process, hire a trademark attorney prior to you even establishing use of the trademark on social media, or in your podcast ventures as well. So it's just very important, because anyone at any time can file for a trademark that you're using, and it doesn't have to be the same exact trademark. It can actually be a trademark that's just closely related or similar. So the importance is, it can be very costly um, on the back end, if you have to, fight cease and desist letters, or maybe, someone may, knowing of a professional athlete's earnings in terms of their financial standing, they may want to kind of in a weird way extort you so that you can pay them money just to have rights for a trademark that you have already been using. So that's the importance of it, specifically for sports professionals.
Yeah, squatting and trolling, these are real world issues. Tell me, have you like worked with like some high profile clients that you could mention in the interview?
Yeah. And again, this, a lot, I know we're speaking on sports professionals here, but most of this stuff is, trademarks is trademarks. So there's no distinction between someone that's in sports, someone that's in music, someone who runs and operates a restaurant. The trademark laws are pretty much consistent across the board for everyone. Um, but I would say the worst case scenario here that I've read up on and that I'm very familiar with. So we can touch on two things. So one, let's talk about Michael Jordan. And this is actually to no fault of his own, actually. He was in a dispute for over 8 years with a company based in China that was using a logo similar to the Jumpman logo that is very popular. I think it came about in 1986 when that logo was first put to use. And this company in China used a silhouette that was similar to the Jumpman, but just from the average person's perspective, they can tell that the logo that was being used in China was somehow connected to Michael Jordan, even though Michael Jordan never had any direct affiliation with this company in China. It cost him a lot of money because that company in China, they were actually very profitable, but Michael Jordan didn't receive any type of compensation for the money that they was bringing in off of his name, image, and likeness. And so he was in an 8-year battle um, with the trademark with that company over there in China with the Chinese government. And so I would say when you're a sports professional and you have somewhat of a global reach, you have to be able to foresee that your reach is much more further than the United States. Okay. you have to be able to establish and foresee markets that and this is where a trademark attorney will come into play, because a trademark office or a trademark attorney will be able to advise you on these things. You have to be able to foresee where there are other markets that you would like to offer your services. There are major markets around the world. You have United States, you have China, you have India, and you have Europe, the EU and the UK. Those are pretty much the primary markets where businesses are flourishing, where people want to sell and offer products and services. So I would say that's a worst case scenario. It's just um, believing that you're protected in the US. What you may be protected in the US, but there are other markets that you're ignoring um, that could in some way be hurting your pockets or infringing upon your trademark rights. So I would say that would be the worst case scenario, just being blind to your global reach as a professional athlete or professional entertainer. Don't be restricted to just the United States, because you have fans and you have viewers that they're very intrigued with you in a weird way, right? So just be aware of that. Um, Best case scenario is just hiring a trademark attorney and just being completely informed of your trademark rights. If you're able to get trademark rights and maintain those trademark rights, um, over the period of being in business, that would be the best case scenario. It's just having the trademark rights secured, and in many markets as possible, outside of just the United States.
Can you tell us about using emblems, brands like the National Football League as parts of a sports apparel brand?
So the National Football League is their trademarks are owned by the National Football League. So the NFL is the NFL emblem is owned by the National Football League. And so use of those trademarks, and they have 32 different organizations that are also um, housed under the National Football League. So using an emblem without any emblem, whether it's the NFL, the MLB, the NBA, using their emblem with unauthorized, with without their permission is clear trademark infringement. Athletes that work or are employed by the NFL, before they decide to use the NFL emblem in connection with any service or product that they offer, they should always seek the approval of the NFL before offering a service or product that uses the NFL emblem. Rarely do you ever see athletes use the NFL emblem. The NFL is very protective, or any sports organization for that matter, is very protective over their trademarks, because with professional athletes, not most professional athletes, but you have quite a few professional athletes that have a lot of media drama and coverage that may be negative and may put the NFL in a negative light. So you, as a professional, sports professional, you can't just use um, the emblems of the leagues that you are employed by, because they may not want to be associated with certain things that you have going outside or going on outside of the the professional league. So your personal ventures, different podcasts, conversations that you may have, they may not want to be affiliated with those particular things, although you are employed by the NFL. I actually, just speaking of this situation, I actually had a client. Well, she was a prospective client. We never went forward with getting a retainer, but she's a former Olympian. And I don't want to say former Olympia because once you're an Olympian, you're always an Olympian. But she was an Olympian, and she had I want to say a charitable organization that she wanted to market herself, letting the public know that she was an Olympian. So she wanted to use the Olympic rings or some variation of it. I think the Olympic rings there's 6 rings, correct? I think there's 6. And she wanted to use 3 rings, but the 3 rings, you can clearly see that this is this looks like Olympic rings, even though there are 3 rings. You can tell that there was some type of connection with the Olympics. And the Olympic Committee, they actually sent her a cease and desist letter, even though she is an Olympian. And when you become an Olympian, it's almost like if you're a doctor, you're a licensed doctor, you're authorized to use the title DR, right? As an attorney, we're allowed to use Esquire. So when you're an Olympian, you are allowed to use the designation OLY. Okay, so she has Olympic medals. She's certified to use the OLY name to let people know that she is an Olympian. However, when she wanted to use the Olympic rings or the logo in connection with her charitable service, the Olympic Committee sent her a cease and desist letter and did not want her using the trademarks, even though she was designated as an Olympian. So using emblems from or logos from organizations that you may be employed under, you have to get authorization, and you just have to be careful because they may not want to even be associated with your own personal ventures.
Do you have maybe an actual success story of a small business registering a trademark, perhaps a small business based on a certain sports,
Yeah,
a professional athlete's name?
yeah, it's one of my favorites. Um, and this is not a particular athlete, but it has a lot to do with the sports industry. So prior to joining Trademarkia, I had a close friend who's in the fitness industry. He's based in Washington, D.C. And the Washington Nationals, which is a Major League Baseball organization, they have a lot of trademarks, right? And this is actually public, so there's nothing that's confidential about this. But my client, he currently owns, or at least he filed for a trademark for We Fit DC. And We Fit DC it's a fitness organization that promotes health and wellness. And he reached out to me one day and he said, "Hey, the Washington Nationals just reached out to me with a cease and desist letter. They would like me to surrender the rights to my We Fit DC trademark." And so they also sent a settlement agreement as well. And so I advised him. He was a friend. He was a close friend, so he didn't have to pay me for this. But I simply advised him after reading through the cease and desist letter. I advised him that it was baseless and that he should just simply, and this is probably not the best advice, but it was so baseless that I advised him that he should not respond to the cease and desist letter because it didn't make any sense, right? And I also advised him not to sign the settlement agreement because he would pretty much agree to surrender his rights to a trademark that they will never use. Um, the industries are completely different. He's in the fitness industry. They're focused on baseball, but the mere use of the letters DC in his trademark, I guess it triggered something for the Nationals legal counsel. And so I would say maybe a few weeks after advising him to not sign the settlement agreement and to ignore the baseless cease and desist letter, the Washington Nationals, they ended up filing a motion to withdraw their opposition against my friend. And then they moved his application towards publication to get the trademark registered. And to this day, he still owns the trademark. So that was one of my favorite experiences because I felt like he was a small business, right? He's just a one-man operation who has his own fitness company. And here you have this multi-billion dollar Major League Baseball organization that's seeking to relinquish his trademark rights, but it didn't work. So in that case, the small business, the single person operation was able to, be victorious against the big whale, which I would say that has, billions of dollars to expend towards legal expenses and legal proceedings.
So kind of a game of chicken, apparently. This seems to be the case in many legal affairs, but at the end of the day, solid legal advice, even if succinct, as in your case and your friends, is the best way to go, right?
Yes, is the best way to go.
All righty. Great getting to know you and really great stories. And I'll be reaching out if we need anything more. So thanks a lot for your time and have a great day.
All right. Thanks, Alex. Thanks for having me. Have a great day.
Bye bye.
Protect your brand with Trademarkia. Register your trademark on trademarkia.com.